Hello,
Welcome to
everyone, and welcome to
immigrationquestion.com,
today's live
your
webinar
go-to
brought to you
resource for
by
U.S. Welcome to
immigrationquestion.com.
immigrationquestion.com, your go-to resource for U.S. immigration insights. We provide clear immigration news and information. Our platform provides a network of licensed attorneys who can answer your questions and guide you through the process. From visas to green cards, asylums to citizenships, immigrationquestion.com helps you to network with immigration attorneys so that you can move forward with confidence. Sign up today or download the app. Free registration, limited time offer. Stay tuned. We go live in 30 seconds.
Hello, everyone, and welcome to today's live webinar brought to you by immigrationquestion.com, a networking platform and meeting ground where immigrants, families, and licensed immigration attorneys engage, learn, and stay informed on the latest developments in US immigration. My name is Shelton Prince, and I'll be your host for today's session. Criminal convictions and deportation, understanding the legal consequences. A criminal conviction can change everything in an immigration case, from green card eligibility to deportation risks, and even minor offenses can trigger significant immigration consequences, often the ones people never expect. Understanding how criminal and immigration law intersect is critical for everyone with a record, for those advising a loved one, or for those actively facing removal proceedings. To guide us through this complex topic, we're joined by attorney Onyinye Esquire. She specializes in the intersection of criminal law and deportation defense. She has extensive experience in securing humanitarian relief, including asylum, U visas, and cancellation of removal. Her strategic advocacy in high stakes removal cases, combined with her mentorship at the Southern Illinois University School of Law Immigration Clinic, gives her a unique perspective on protecting immigrants facing criminal related immigration issues. You're welcome, Onyinye Otedi. We are thrilled to have you join the series.
Thank you so much.
Before we begin, a quick reminder, immigrationquestion.com is not a law firm and does not provide legal advice, representation, or services. This platform serves as a public meeting ground where individuals can learn about immigration topics and engage with licensed attorneys who participate independently. To our viewers tuning in from Facebook, YouTube, LinkedIn, and everywhere else, welcome. If you haven't subscribed yet, now is the perfect time. Go ahead, hit that subscribe button, grab your notepads, and let's dive into today's session. Attorney Onyinye, when a non-citizen is convicted of a crime, what are the first legal factors that determine whether the conviction may lead to removal proceedings?
Thank you very much. When it comes to the immigration consequence of criminal convictions, it's less important how the state law defines the conviction in question, and more important on how the immigration law categorizes it. So there are three major factors that affect whether a person is going to be put in removal proceedings or not. The first thing is the type of offense. Under immigration law, there's a question of, is the offense in question a deportable offense, or is the offense one of inadmissibility? The second thing is, what are the statutory elements of the offense in question? Because immigration law looks at the elements of an offense, like what are the things that makes this an offense, not just the person's specific conduct, but how does immigration law categorize the offense? The third thing is the sentence imposed. Sometimes for some kind of offenses like aggravated felonies, it's the sentence attached to the conviction that triggers whether the offense in question or the conviction is an aggravated felony or not. And then additional factors like offense convictions involving controlled substance, domestic violence, firearms. Those are also other things that could trigger a person being put in removal proceeding. So on the whole, Immigration looks at what the statute requires the prosecutor, what was proved in the course of the trial, and how serious it is under immigration law.
All right, perfect. Thank you. Um, some offences are classified as aggravated felonies or crimes involving moral turpitude. How do immigration officers distinguish between these categories, and why do they carry such a serious consequence?
For aggravated felonies and crimes involving moral turpitude, known as CIMTs, these are offenses, categories of offenses that are very, very important for a person, a non US citizen. First, for
Hmm.
aggravated felonies are defined by the INA, the Immigration and Nationality Act, and any offense that fits into the definition. It's a very broad definition. It includes fraud, theft, drug trafficking, and of crimes of violence. However, for aggravated felony, there is the sentence requirements of 1 year.
Hmm.
So once a person is convicted of an offense that fits into this definition and gets the sentence of 1 year, is automatically an aggravated felony. And the consequences of aggravated felony includes it's almost an automatic deportation. It reduces a lot of relief a person is eligible for. And for some immigration reliefs, an aggravated felony is a permanent bar, something like
Hmm.
asylum. A person convicted of that, of an aggravated felony, is ineligible for asylum, cancellation of removal, and things like that. But for
Hmm.
crimes of violence, it's not defined by the statutes. So over time, case laws have played a very important part in defining what is a CIMT. And it's either an offense considered to be morally unacceptable, something involving
Hmm.
fraud, theft, in intentions to harm, and then the
Hmm.
consequences of CIMT are somewhat less harming than aggravated felonies because some CIMTs can make a person deportable or inadmissible, and it depends on the timing of the conviction
Hmm.
and the number of convictions. But then they are much more flexible than the aggravated felony, and they are still serious. And the CIMT has an exception called the petty offense exception, but aggravated
Okay.
felony, it doesn't have that exception. So they are to distinguish them. It's basically for the aggravated felony. It's defined by the federal statute, while the crimes
Hmm.
against moral turpitude is defined by case law.
Interesting. Thank you for that answer. And the next question is how does the timing of a conviction, such as whether it occurred before or after obtaining lawful permanent residence, affect a person's risk of deportation?
Okay, so beyond the importance of the offense itself, the timing of the offense is very, very important,
Hmm.
particularly for a green card holder. So
Okay.
offenses that are convictions of offenses before a person's obtained their green card folder, sorry, their green card is actually evaluated under the inadmissibility ground. I could go into what it's an inadmissibility ground, but it's going to take a long time.
Hmm.
But just to ground it up, there are
Yeah.
offenses that trigger inadmissibility. CIMTs can trigger inadmissibility besides the petty
Hmm.
offense exception, and then there's a youthful offender exception. Controlled substance can trigger inadmissibility, multiple criminal convictions with an aggregate of 5 years jail time, and other things they could trigger inadmissibility. And
Hmm.
this is a thing. It matters that a person is inadmissible if the person does not have a green card. It's not a legal permanent resident. But after a person
Right.
obtains a green card or is a legal permanent resident, any offense that falls that are very similar to these same offenses that affect inadmissibility are considered as deportable offense. But
Mm-hmm.
there are wiggle rooms. The law treats the offenses differently because there are waivers, there are cancellations available for the green card holder after they are permanent residents, and but then these are not very much available to them before they get
Mm-hmm.
their green card. So on the whole, some offenses can be harmless if they happen before a
Mm-hmm.
person gets their green card. But the moment the
Okay.
person gets their permanent residency, in that same set of offense makes them deportable.
Sure. Interesting. So, I mean, many individuals believe that expungements or reduced charges eliminates immigration consequences. So, from your experience, how do post-conviction changes actually affect a person's immigration status?
I'm just going to say this for free to anyone who cares to listen. A criminal court cleanup, scrubbing of the record, it does not clean up your immigration law record. It does not clean up the immigration record. Rather,
Yeah.
it makes it difficult for your attorney and for
Mm-hmm.
yourself down the line. Because while the person might not be able to access these records, regardless of whether
Mm-hmm.
it's expunged, sealed, the government has access to it. I cannot see it, you cannot see it, but the government can see it. So it's still there.
Wow. Jeez.
But
Okay.
then for dismissals, reduced charges, it does not erase the immigration consequences, but sometimes it significantly changes it. For
Okay.
instance, when a person is convicted of an aggravated felony and
Mm-hmm.
the conviction is for more than a year, the person
Mm-hmm.
is barred from so much. But with the
Okay.
same conviction, but then the sentence is for probation of 10 years probation, the immigration consequence is way less than a person who gets 1 year jail time because the 1 year
I
jail
see.
time makes that conviction an aggravated felony, while the probation takes it out of the realm of an aggravated felony. So it could be a CIMT, but definitely not an
Yeah.
aggravated felony. So you see, it's the dismissal, reduced charge, it changes the immigration
Mhm.
consequently significantly.
Alrighty, interesting. So for immigrants facing pending charges, what steps should they take to understand how a plea or conviction might impact their ability to remain in the United States?
Okay. I know that not a lot of people fancy the idea of speaking with an attorney, but for
Hmm.
any person who is not a who is a non-US citizen and has a pending criminal charge,
Hmm.
please always speak to an attorney, consult an immigration attorney. It's very, very important because the prosecutor could offer a plea that looks good,
Yeah.
but on the long run, that plea could harm you. So it's
Hmm.
very important to speak to an immigration attorney before make taking a plea. Some criminal attorneys are not well knowledgeable on the immigration law consequences of certain convictions. So they would advise you as criminal attorneys, but
Hmm.
a person who is a non-citizen, it's very, very important that the person consults an immigration attorney before they go ahead with taking a plea. So it's very important to
Okay.
get that consult.
Makes sense. So for someone that has a criminal history, but very strong family ties, long-term residence, or other equities, what legal pathways or forms of relief may still be available during removal proceedings?
So it depends on, it honestly depends on so many factors. However, there's still a list of common relief options available to a person who has criminal history but has strong ties in the community. and the person is in removal. So the first is the cancellation of removal. So there are three types of cancellation of removal. There's a cancellation of removal for permanent residents. There's a cancellation of removal for non-permanent residents. And then there's
Hmm.
the cancellation of removal for people who are victims of domestic violence. For the first one, if the person has permanent residency and is in removal
Hmm.
and has been in the US for a continuous 7 years before they were put in removal,
Okay.
there's a legal part, there's a pathway out of it. And so that's the relief for people who, for non-LPRs, non-legal permanent residents who's been in the
Hmm.
US for at least 10 years before they were put in removal or before they apply for cancellation of their removal. That's a part. There's still asylum, withholding of removal, especially if the person is not convicted of an offense that bars them from this. There's that.
Mm.
There's persecutorial discretion, which used to be a
Okay.
thing, but it's not really a thing anymore. But on paper, it's still a thing. On paper, there's still persecutorial discretion or administrative closure, but it's not really a thing. And this strongly depends. It depends so much on the government's policies and humanitarian factors. But
Okay.
there are all of these reliefs, including persecutorial discretion and administrative closure, but
Hmm.
I wouldn't bank on the last. I'll bank more on the other ones and less on the last. So, yeah, so basically, even with a criminal record, many people are not automatically deported. Many people are not automatically cut off from reliefs in immigration court, even with a criminal conviction.
All right, perfect. Jedidiah, thank you so much for answering those questions.
Thank you.
So yeah, to everyone joining us live, just thank you for being part of this critical conversation. Criminal convictions can have life-changing immigration consequences, and staying informed can make a meaningful difference in planning, response, and legal strategy. If this is your first time tuning in, welcome. Immigrationquestion.com is a networking platform where immigrants and families can ask immigration related questions for free and engage directly with licensed attorneys. Many users may also qualify for a free confidential consultation. We are also proud to share that immigrationquestion.com is a triple B accredited, reflecting our commitment to transparency, accountability, and community education. Attorney Onyinye, based on your experience at the intersection of criminal and immigration law, how do you view platforms like immigrationquestion.com in helping immigrants understand their options and respond strategically to convictions or pending charges?
Personally, I first of all, I commend this platform as being available because it's very important, particularly in given the times we're in, where immigration is a hot topic and it's a thing that it's if you open your phone, that's the first thing you see sometime when you log on to social media. So
Yeah.
creating this platform and avenues for people to safely reach out to you and have the space to connect with an attorney who could help them, and
Okay.
particularly persons with criminal convictions. It's a commendable platform, and
Mhm.
I'm glad that there's something like that to help people.
Thank you for again for that valuable insights. So before we move into our live Q&A, here's one more question. So in light of recent developments, what practical steps should immigrants with criminal records take right now to protect their immigration status and avoid mistakes that could trigger removal?
The first thing I'm going to say is consult an immigration attorney, regardless of whether you think your criminal conviction is the little one or the big one, or it's
Mhm.
serious or it's not serious. Schedule a consultation with an immigration attorney because you need to be
Okay.
informed
Mhm.
so that if anything comes up, you're ready for whatever it is. So any person who has a criminal conviction, consult an attorney, weigh your
Mhm.
options, and be proactive about your case.
Okay. Perfect. Thank you for that. I think we'll move into the audience questions. So the first question we have here from Crystal Nzovu. So I was charged with the misdemeanor shoplifting case last year. Can something this small still get me deported?
Okay, the first thing I'll have to highlight is that first, this is not a legal advice. This is not a legal advice, but I'm just going to highlight. So, in a case where a person has been convicted of shoplifting previously, there are a couple of
Mhm.
things I would need for you to, I would advise you need to consult with an attorney. It's very important, particularly since the rise of the Laken Riley Act, which is the Laken Riley Act. It's an act that mandates the detention of certain non-citizens charged with theft-related offense, and shoplifting is a theft-related offense. I don't know when it happened, but if it happened after the Laken Riley Act, you need to speak with an attorney. So you're on top of your case, just in case something happens. Just in case. I hope it doesn't happen, but just in case. But if it happened before the Laken Riley Act, I would still say you should consult an attorney just to be on top of your case, because I know at some point there was a debate on whether or not the Laken Riley Act would have a retrospective um, effect or not. So I would still say you might need to speak with your attorney, because while this is small, it could affect whether or not you're deportable or not. If any reason you get into anything with law enforcement, and you're arrested, and your criminal history is looked into, it could pop up all manner of things. So, yes, it could. I hope it doesn't. But like I said, it's something that if it ever happens, connect with an attorney.
Thank you
I
so
hope that
much.
answered the question.
Definitely, I certainly think you did. Next question that we've got here is from Rodolfo Jimenez. So the question is, my immigration also said my conviction might be considered a crime of moral turpitude. What does that actually mean for my green card?
Like I mentioned in the course of this conversation, it depends strongly when this crime happened. One, two, it depends where it happened. Because if you recall, when I was talking about CIMTs, I said it depends so much on case law for definition. And then when we're talking about case law, immigration law depends so much on circuit. What could be an issue in the Seventh Circuit might not be something that is an issue in the Eighth Circuit.
Mhm.
So the first thing is, if your immigration attorney believes that it's a crime against moral turpitude, what does this actually mean for your green card? If this happened before you got your green card, it was an issue of inadmissibility. But if this happened after, it's something that can trigger deportability. I'm not saying it has, but it could. So it's something that if for any reason you have any issues with law enforcement or immigration, speak with your immigration attorney before you make any decisions, because this could be a thing of concern.
So thank you for that. Next question we've got here. Next question is from Alu Wasagan Arameda. So the question is, I pled guilty to a charge because the public defender said it wouldn't affect immigration. But now the USCIS is questioning it. What can I do?
I'll tell you, free of charge, you need to get an attorney. You might need to get you need I don't you might not you need to get an attorney, because I we talked about this earlier. Sometimes criminal attorneys are not well learned on consequences of immigration, how the criminal convictions affect immigration status.
Mm-hmm.
There's something called Padilla. The Padilla thing is it's a decision from the Supreme Court that states that before a person, a non-U.S. citizen, is convicted or pleads to a particular charge, that they are supposed to be
Mm-hmm.
advised on the immigration consequences. And over time, Padilla has also the Padilla case, the matter of Padilla has been a ground on which to challenge judgments that were entered without proper immigration advisors. So now that you're having issues with USCIS about this, the first thing you need to do, you need to consult an attorney to find a
Mm-hmm.
way to figure this out. And there might be need to go to the roots to fix this, like maybe go back to the criminal court to find a way to deal with this, or get an attorney help you navigate this at the USCIS level.
Okay, interesting. Thank you so much. Next question that we've got here. Next question is from Jermaine Carter. And his question reads, can immigration detain someone immediately after they finish their criminal sentence?
You don't want to know how often this happens. Like, you do not want to know how often this happened. And this was before this year. There are people who are put in removal proceedings while they are
Mm-hmm.
still serving their criminal sentence.
Jeez.
Yes. And then there are
Sure.
people who, after serving their criminal sentence, and then
Mm-hmm.
the officers at the jail tell them, pack it up, it's time to go. As they are leaving, ICE is waiting for them at the gate of the detention, telling them, okay,
Jeez.
over to ICE custody. So yes, it happens. You don't want to know how often it happens, but yes, it does happen.
Interesting. Sure. Alrighty. Thanks for that, Onyinye. Next question. So the question we have here is from Tatiana Kozak. So her question is, I have a DUI, but no other problems. Is a single DUI enough to trigger removal proceedings?
I'm very sorry, I'm going to respond to this as an attorney. First, always remember this is not a legal advice, but secondly, it depends. I'm sorry, that's how I'm going to answer, but it depends. What does it depend on?
Mm-hmm.
Before the year 2005, I would have said it depends, but most likely not. But
Mm-hmm.
one of the things that affects immigration policy is public policies. And when I say public policy, if you're conversant with what's going on what has been on the internet, is the fact that DUI has been a hot topic. DUI has been a thing that everyone is like, any person with DUI has committed the worst
Mm-hmm.
crime. So at the moment, I want to say it depends on so much. One,
Yeah.
it depends on whether you're a lawful permanent resident or not. So it could be an inadmissibility
Yeah.
ground, but on its own, generally, it honestly depends. It depends on so many things. But while even if on its own it does not trigger removability, if for any
Mm-hmm.
reason your legal status is in question, a DUI could weigh heavy on the negative equities that are considered in determining in determining your status. But so I would just say it depends. Well, if for any reason anything happens or where you think it might be a problem, consult an attorney, get an attorney.
Makes so much sense. Thank you so much. And I think we got one last question. Yeah. The last question is from Chichoke Izenwa. So the question is, what types of criminal convictions automatically make someone inadmissible versus deportable?
Okay. So for inadmissibility, first of all, if a person is not a legal permanent resident, offenses that can trigger inadmissibility, the first are crimes involving moral turpitude, which are crimes like fraud, theft, anything that is considered morally reprehensible. The second thing is controlled substance offenses, any drug conviction, multiple crime convictions that on the aggregate has more than 5 years of jail time, offenses involving prostitution, commercialized vices, human trafficking, drug trafficking, serious foreign convictions. Before the person has legal permanent residence, it makes them inadmissible. But for deportability, on the other hand, when a person has legal permanent residence and is convicted of a crime involving moral turpitude, controlled
Mhm.
substance convictions, aggravated felonies. Aggravated felonies are what the law says they are. That's the best way to define aggravated felony. What the law calls aggravated felonies are aggravated felonies. Firearm offenses, domestic violence, stalking, violation of protective order, drug abuses, drug addictions, those can trigger deportability. So they are deportable offense. So you see, they are kind of similar, but it
Mhm.
depends on when it happens. If it's before legal residency or after legal residency.
Interesting. Thank you so much for answering the question.
Yeah.
No, I think that's all the time we got for questions. So I think, Atinya, I want to move on to the news bit section here, and I think, we also just want to briefly touch on a recent development. So a federal judge has ordered the government to restore legal access for migrants held in a downtown Los Angeles facility. How should immigrants and their advocates interpret this ruling? And what steps can they take to stay informed about how it may affect ongoing removal cases or detention scenarios?
Okay. So first thing first is that this particular decision, it reinforces the fact that all individuals, regardless of their immigration status, have a right to due process and legal representation. And this particular decision by the federal judge came as a result of detainees being deprived of adequate access to counsel, and
Hmm.
this violates their Fifth Amendment rights. And particularly, any person who is detained has ICE, the government is supposed to grant them access to legal visits 7 days a week, provide confidential spaces for the discussions with attorney, and ensure that
Hmm.
the calls are not recorded. It's very important that they maintain the confidentiality. And how do people
Hmm.
with relatives who are detained ensure that they take advantage of this constitutional provision? I'm not going to emphasize it so much. It's not because I'm an immigration attorney, but it's because it's very important to have an immigration attorney, because your
Hmm.
immigration attorney is able to fight for you when you're not able to fight. The immigration process on itself, it's very complex. The removal process, it's very, very complex. And going into it without being armed properly puts a person at a disadvantage. So when a person who's detained is not able to connect with their attorney, but
Hmm.
I need to mention the flip side of this constitutional provision is that this due process, it's basically for legal representation. So this
Hmm.
cannot be relied on to say I'm not able to speak with my family. That's where the attorney advocacy comes in. If you're not able to speak with your family, but you're able to speak with
Hmm.
your attorney can advocate for those things for you. So having an attorney and being able to get legal representation is part of the constitutionally given rights for persons detained, regardless of their immigration status. So extending to detained immigrants. Yeah.
Perfect. Thank you so much, Attorney Nunez, and thank you for sharing your expertise and practical guidance today. Your insights, I think, helps individuals and families better understand the consequences of criminal convictions and the strategies available to protect their immigration status. And to all of our viewers, thank you for joining today's webinar. We hope the session helps you stay informed, prepared, and confident as you navigate the intersections of criminal and immigration law. Remember, you can always visit immigrationquestion.com to ask immigration questions for free and connect with licensed attorneys. Many users may also qualify for a free confidential consultation. If you'd like to revisit today's discussion or share it with others, the full replay will be available on Spotify soon. Search for Borderless Talk by immigrationquestion.com. And join us again next week for another live session covering critical topics, including family petitions, asylum updates, green cards, and compliance developments. Thank you again, Attorney Onyinye. Thank you for everyone watching. Until next time, stay informed, stay prepared, and stay connected. Goodbye, everybody.